My name is Rich Balceros. I'm an estate planning attorney here in Contra Costa County. And the person on the right of that picture is with the law office of Tim Batts. Tim is a probate attorney. We'll have a little more introduction in a moment. I'm going to go ahead and read a disclaimer. I'll be really quick. The information contained in this PowerPoint presentation or in any of the web-based broadcasts utilizing this content is provided for discussion and educational purposes only. It's intended to facilitate dialogue on the various topics presented and should not be construed as financial or legal advice, nor should it be interpreted as an offer, guarantee, or estimate of settlement value. The data, assessments, and opinions set forth herein are subject to change and may not reflect current or accurate information at the time of your review. This material is intended solely for the use of the individual entity to which it is addressed, whether through direct delivery, webcast, or other digital means, and may contain confidential or privileged information. Unauthorized disclosure, use, dissemination, copying of this material or any part of its contents, regardless of the platform used, is strictly prohibited and may be unlawful. Before making any financial or legal decisions, it's advisable to consult with qualified professionals who can provide advice specific to your individual circumstances. Neither the authors, presenters, nor any other parties involved in creation or delivery of this presentation or broadcast shall be liable for any damages, including without limitation, direct, incidental, consequential, indirect, or punitive damages arising from access to, use of, or inability to use the content presented or any errors or omissions of the content thereof. As an attorney, you got to have a disclaimer, right? This is for educational purposes only. First, I'd like to thank you all for taking the time out of your busy day. We hope that this will last an hour, maybe an hour and a half, depending on the amount of questions. If you do have questions, we could queue them up in the chat and then we'll pause for questions, but we do appreciate, feel free to unmute yourself and say, hey, I got a quick question. We'll try to address it, but we're also trying to be respectful of everybody's time on a weeknight. On a Wednesday when everybody got to go to work the next day and things like that. So we're going to try to go through this at a very high level and but at the same time, want to educate everybody on probate and estate plannings. So Tim, do you want to provide an introduction of your practice?
Sure. My name is Tim Batts. I have primarily a probate administration practice. My main office is based in Oakland, California. I do probates throughout Northern California in multiple counties, Contra Costa, Sacramento, Yolo, San Francisco, you name it. If it's in Northern California, I probably have a probate that's active right now there. And I'll get more into how the counties differ further in the broadcast, but for the most part, that's mainly what I do, and I do some personal injury litigation.
Okay. And I'm Rich Balceros, like I mentioned, estate planning attorney. We do have some other practice areas, but you can view those on our website. I've been doing non-taxable estates since 2009. Excuse me, I'm fighting off a cold. And so with that being said, we had our introductions. Tim's going to go ahead and we're going to talk about probate and go through a high-level overview of probate and what that entails. And then after we get to about bullet point 6, I'll transition to the estate planning side of things in an effort to try to avoid probate. So, Tim, I'm ready when you are.
Okay, let's get to that first slide. Okay, probate is a legal process that involves the court to administer a person's estate when a person dies. So basically, in a nutshell, probate is the process that's governed by the courts where the assets a person leaves at their death are distributed amongst the heirs as determined by either a will or the law. And that process is sort of supervised by the court. So that's the process. Whether you have a will or you don't have a will, your material assets are divided up based on a process called probate. Next slide. Probate the probate court is a process by which the state appoints an administrator to identify and gather your assets. And notify your creditors. So basically, that's the overarching picture. What happens is you file a document called a petition for probate, and that petition, it's a DE 111, is filed by everyone, regardless of whether you have a will or you don't have a will. You file this petition, and this petition is sort of a request for the court that they appoint an administrator if you don't have a will, or an executor if you have a will and a person is identified in that will, to gather your assets, contact individuals that have an interest in the assets, and distribute those assets amongst individuals who are heirs or interested parties, namely creditors, or the state, franchise tax board, Department of Health, or other interested governmental agencies. Next slide. Probate is time intensive. The state appointed administrator, or the executor, if you had a will that identified an executor, identifies, gathers the assets, notifies creditors, pays your taxes and debts, and distributes your assets. Now, it sounds like that's something that could happen expeditiously, but each of these processes has formalities surrounding them, from filing that DE 111 that I told you about earlier, to notifying your heirs, to publication of the document in a newspaper or in some publication that is sufficiently broad in its publication to reach a sufficient number of people to be considered sufficient for the court to say, okay, you've published enough, and it has to be published 3 times over 5 weeks. So that takes time. And then each time you file with the court, the court will provide you with a review. This review process is done by what's called probate examiners, and they issue these notes before each hearing. And these notes have to be, what they do is they detect deficiencies in the filing, and you have to clear these notes before the next hearing, or you get another hearing date. Now, I have probates going in Yolo County, in Sacramento County, in San Francisco County, in Alameda County, in Contra Costa County, and in all of these counties, the overall process is the same. You file that DE 111, the petition for probate, and the examiners will review that document and see if they discover information that you need to add, or if information leads them to questions about other documents that they need, whether there are documents that explain the will itself, or whether there are documents that identify heirs that weren't listed, or whether they're documents that require additional information. And they'll put those in the notes, and then your job is to provide them with whatever they request in those notes. This adds to the timeline. So probate is time intensive. It's because of the process through which the probate examiners request the additional information and the formalities associated with the probate process itself. Next slide. At the end of the probate process, your probate estate is distributed under the terms of your will, or if you don't have a will, under California's default rule known as intestacy. What that basically means is, at the end of the entire process of gathering the assets, identifying the heirs, so providing sufficient the 3 notices that are required for proof of publication, following the other formalities associated with the will process. There are these laws, if you don't have a will, that determine who are your heirs. And they're set up based on the probate code, and the probate code identifies for you individuals that are somehow related to you by blood or by law through adoption, and these individuals become your heirs. And then based on what assets remain after creditors have been satisfied and government entities like the Franchise Tax Board or the Department of Health Services or whomever else have collected from the estate what may be owed to these entities. And whatever's left are divided amongst these heirs at law. And that's intestacy succession, but all of these individuals start in the same place, filing that petition for probate, filing the DE 111, and responding to the request or those identified deficiencies based on what the probate notes read from the probate examiners. Next slide. Now, your will tells the court how to distribute your probate assets. Now, from the last slide, we know that everybody starts in the same place, will or no will. And if you don't have a will, you move through the probate process through intestate succession to the point of distribution of assets that remain after creditors have been satisfied. But there's this common misconception that if you have a will, you avoid probate. As I said from I think it's slide 2, everybody files that same petition. If you have a will, you have to file your DE 111. You have the benefit of attaching your will to DE 111 and lodging your original will, a copy of your will to DE 111, and lodging your original will with the probate court. But that doesn't help you avoid the probate process. You still go through the process. It's a little faster, a little less expensive, but you still go through the probate process. Will or no will.
Real quick, anybody here in the audience been through a probate? Just unmute yourself, just curious. No? Okay.
Yes.
Oh. Hi.
Hi.
How long did your probate process last?
It didn't last as long as most people say. For me, that is. But it did with not with my husband, but it did with his sister when I took over her.
And was that a year or shorter?
No, it wasn't a year. Well, let me tell you, I'm still working with the one she got in 2016. And I'm still back and forth with the individual that helped with her paperwork.
I see.
And she seems to not want to answer the questions or pass out the information that she told me that she would send.
Oh, wow. Okay.
Yeah.
So you said 2016.
Yep.
Is that right?
Well, then she kept kind of contact her. Then I ended up kind of talking with someone else because she ended up getting married and didn't follow through. And then after COVID, she asked me to give her a call back, and I did. And I just called the other day, and she said she didn't recognize the number. So she was just trying to find out who it was, and she called me back. Well, I have not gotten that call yet.
Oh, wow.
Yep.
So, but you are talking like 8 years. I mean, give or take, with the COVID obviously delayed a lot of stuff, but that's still a long time.
It didn't. Yeah, you're right. It did, and I sent all kinds of things to her, picture, all kinds of things of my sister-in-law, and still she didn't follow through. But she did take my check.
Yeah. Sorry to hear that, Ms. Peoples. But yeah, but not a very pleasant experience though, right? Going through probate.
No, and I don't really want to go through it with me. And that's the reason I'm on here now, trying to hear what all that needs to be said about probate, because I was so dissatisfied with probate. I refused to go through it. And then people tell me, well, you have to work how it's worded to make sure that things are carried out like they're supposed to. And I've gone to all kinds of classes and been on all kinds of workshops and webinars. And I'm still not quite convinced.
Quite convinced. Okay. Well, thank you for the feedback. I appreciate it. We'll go ahead and continue. I'll go to the next slide, Tim.
Yeah, next slide.
Oh, and real quick, Tim, I mean, what's the longest probate you've worked on?
The longest probate I've worked on is one in San Francisco. It's still going. It started 9 years ago, and it was complex probate. It had an apartment, a small apartment, 6 units, and 2 houses, and some personal property. But the reason it's taken so long, and it's down to one asset now, it's just the home, was there was a contest. One of the heirs wasn't an heir, but was a cousin, challenged the probate because they had been left out of the will. And so that created a time lag in the beginning, but that was dispensed with. And then the heirs got into a disagreement over who was supposed to receive what, even though it was clear from the will that it was supposed to be divided between 2 sons and a grandson. And so
having a contest can change the length of time.
oh yeah, yeah, a contested will and the number of assets in the estate can lengthen the time that it takes for a will to get resolved. So a will makes the process go faster, but a contested will slow down the process a great deal. And
So here's the probate process, Tim.
here's the probate process. So as I've been stating all along, the first step is filing that probate petition, that petition for probate, and that's a DE 111, and all the counties use that same judicial council form, and you complete that. It's an involved form, but what it does is it provides the court with information on the decedent, on the person who's seeking to become the executor or the administrator, depending on whether there's a will or not a will. And it asks questions about the assets in the estate, and then it asks a whole host of other questions about the heirs and that sort of thing. But those are the main areas of questions it asks. And then you file that, and then once it's filed, you get a case number and you get a hearing date. And the hearing date, depending on what jurisdiction you're in, which county, is either the quickest I've seen is 8 weeks, but they're saying 5 to 6 weeks. The quickest I've seen, and that was in Yolo County. And if things go perfectly, by the time the 8 weeks rolls around, you're close to having everything you need to have done, completed, so that you can almost request that the order for probate and the letters of testamentary or letters of administration, depending on whether you're an executor or administrator, be issued at the time of the hearing. I don't usually see that happening. I haven't seen that happen on any of the estates I've been on. Usually it gets continued for another hearing because either the proof of publication hasn't come through, or they need the proof of subscribing witnesses or some other document the examiner is asking for, and it's not available. So it usually takes more time than that, and you have to clear probate notes before you can get that. But if everything works out the way it's supposed to work out, then at the end of between 12 and 18 months, you usually are able to distribute the remaining assets to all the heirs and close the estate in some places. But my experience is it's more like 18 to 24 months in a single estate, a single asset estate with no contest between the heirs and no third party contest where you have folks coming out and claiming an interest in the assets that aren't listed in the will or aren't heirs by law.
Okay. Next slide, Tim.
Next slide.
All right. Probate costs.
These are the probate costs. Now, unlike many other areas of law, probate administration sets up the costs that you should generally have for your attorney and the executor. It has a downward scaling rate. So you pay 4% on the first 100,000 of the estate, 3% on the second 100,000 of the estate, 2% on the next 800,000 of the estate, 1% on the next 9 million of the estate, and 0.5% on the next 15 million of the estate. So $1 million estate isn't really out of the ordinary in California because you have a house. If you have a house, you're probably at or above $1 million in an estate. A house and a retirement plan, you're probably at or above $1 million in California. And so you would be in the neighborhood with the executor fee of 432 on the first 100, second 100, and the next 800, 2% on the next 800,000. You'd be at 23,000 for your executor's fees, and then the same scale is used for the attorney's fees. So you'd be at 46,000 in fees just for the attorney's fees and the executor's fees if you go through probate with a will. If you go through probate without a will, same thing. So 46,000 of your estate goes to executor fees and attorney's fees. One set of fees that aren't listed here is the 0.1% fee that goes to the appraiser fee. And that's the court-appointed probate referee who appraises the estate to determine the value of the estate for the purposes of generating the fees. And that person is appointed at the time the order for probate is issued by the court. And that person is who reviews the accounting and inventory and makes a determination of the value of the estate for purposes of determining the fees. And in most instances, that'll be a cost that is taken out of the estate before the distribution of the assets. Next slide.
Right, but if there's a test, you can get extraordinary fees.
Yeah, and so in some situations, like in addition to an estate taking an extraordinary amount of time to close, those are the estates where you're going to have fees on top of the statutory fees. And those are situations where the attorney has to do more than just administer the estate. Where the attorney is involved in litigation, the attorney can file a document and request extraordinary fees because they had to fend off third-party challenges to the will, or fend off litigation, or be involved in litigation over the assets in the estate. When that happens, they can request that the court grant them hourly fees on top of the standard fees that are statutory because they have to do more work than just the standard administering the estate. And in those situations, the court generally will grant them reasonable attorney's fees for whatever service that was rendered beyond the standard administering the estate.
Okay. Any questions for Tim before we transition to the next? So real quick summary.
So in summation, the main reasons to avoid probate, other than the obvious ones, is that it even at 12 months or 18 months, and for me, it's been more like 18 to 24, but even at 12 months, which is what the slide says, 12 to 18, there's a way to do it in far less time than 12 to 18 months. And depending on, and that's more county dependent, and that's for an estate that has a single asset, a home, and heirs that aren't contesting the award or the division of the assets, and no third party contest. And so it's an optimistic picture when you talk 1 year to 1.5 years. And then your estate and information becomes public because everything has to be filed with the court, and the court is and estates are public record. Your will, your heirs, your DE 111, and all the information it contains becomes public record, so anyone can find out about it. In addition to that, there's a publication requirement. So the death, the petition itself, the fact that the estate is being probated, all is public record because it's in the newspaper at least three times over a 5-week period, so that everybody, all creditors, all relatives who were left out, anyone can find out that information and do with it what they will, including challenge the petition and challenge the distribution. The process is court supervised because that's how probate works. It's a court process, and probate is more expensive than trust administration, even without extraordinary fees. Even in the best case scenario, you're going to spend more on a probate than you are with trust administration.
Yeah.
And
Thanks,
so those are the main reasons. So that is probate administration from 10,000 feet up. There are other reasons involved too, but in an uncontested single asset, simple estate, you're still talking about a lot of time, and you're still talking about statutory fees.
All right. Thanks, Tim. Appreciate it.
You got it.
All right, so we're going to go through some any questions for Tim before we transition to the next to estate planning itself now? No? Okay. So the first thing to know, and I'm fighting a cold here, so I apologize, is that not everything is subject to probate, right? So we already mentioned wills and not having wills. That's intestate succession, guardianships, and then if your estate is worth less than 185K, just rounding off, you could go through a kind of a simplified probate, but it still has to go through the court. Your life insurance, retirement accounts, trusts, gifts, business agreements, things where you could designate beneficiaries are probate avoidance devices, right? And I think the thing to think about too with the estate planning process, and then hearing Tim discuss it, is all that's going on while you're still like grieving for whoever it was that passed away. So there's a very human component still. So essentially all we're saying is let's have a plan, right? And we're going to go through like the different pieces of that plan here shortly. But it's a speed thing, right? Because probate could go on for, a year or years, right? And it's still not resolved, right? And you're still grieving, but then what if the people that you leave behind still need those assets? So it's still a very human thing. So even though we talked a lot about like the law and the procedure and, high level at the 10,000-foot view, right? There's still a very human thing that's happening on the ground when, someone passes away and they've left assets and the people that are left behind have no plan. So let me get to the next slide. All right, so revocable living trust. Revocable just means you can change it at any time during your lifetime. Let's say you get a married couple gets a revocable living trust. One spouse dies and then there's a surviving spouse. And then once that surviving spouse passes away, then it becomes irrevocable. Now, what a trust is simply like this cup that's holding my tea, that's helping me keep my voice together here right now. Like the cup itself would be the trust, right? And the assets would be, I was going to say the tea bags, but I was going to say the tea inside the tea, right? Would be the assets. So anything that's inside the cup would be protected from probate. This cup happens to be a cup of dad jokes that my 6-year-old daughter bought me from her school gift shop, right? So when I want to get a laugh, I can read one of these, dad joke things on here. But so yeah, so revocable living trust is just a pre-arrangement of property. You would nominate a trustee, and then they would control your assets when, like in the married scenario, when both of you pass away. But while you're alive, you'll essentially be trustees for your beneficiaries to whoever you name, right? And again, it's an attempt to try to avoid the lengthier process of probate. And now you see a will. So why do we have a will here after Tim told us, all wills go to probate? Well, sometimes people draft their estate plans and then they realize they forgot to put things in the trust. So the pour over will is like the belt and suspenders, right? The belt being the trust and the suspenders being the will. So whatever you forgot to put in, the will direct it to the trust, right? And the executor's usually the one in charge of the will, and the trustee is usually in charge of the trust. So that's the main difference between, but they're both kind of in a way, they both have fiduciary duties to the beneficiaries. So I'm gonna pause there. Anybody have any questions? I don't know I'm moving quickly because we're already a half hour through. No? Okay. All right, financial power of attorney. So, let's say, I get sick and I have assets that are, separate. I'm married and I have like an account that doesn't have my wife's name on it, like my secret bank account where I pay for things that I shouldn't, can't afford or whatever, but I just don't want to tell my wife. Just kidding. It never happens. But honestly, if you get sick and incapacitated, right, then someone can step in for you as your agent and then be able to maintain the bills. So let's say I'm sick in the hospital, but bills need to be paid. So someone that I name as my agent who would have a fiduciary duty to me to make sure that they take care of my finances or whatever can step in and like pay the bills while I'm in the hospital. So we've been kind of in an odd way been talking backwards. We've talked about what kind of happens after you pass away, whether you have a plan or not, right? No plan, you have probate. Plan, you have a trust or a will, right? Or both. Excuse me. But this is in the instance, the financial power of attorney is an instance you're still alive, right? But now you can't speak for yourself. So who's in charge of that, right? You might need someone to step in to handle that. So an estate plan isn't just things that happen after we're gone. It's also trying to account for things while you're alive. And again, it's a people thing, it's a speed thing, right? It's also making sure that the instructions and the wishes you leave behind are there to try to mitigate any conflicts you might have for your kids. I got 3 kids right now. They don't necessarily get along, right? So you'll have instructions for them. Let me see what question we got here in the chat. No, I do not. Sorry, Miss McLaren. I'm only licensed in California. So, good question. Appreciate it. Okay. Moving forward. So if any of you are in the healthcare industry or are a nurse or anything like that, you might be familiar with healthcare directives and living wills and HIPAA waivers. So similar situation to the financial power of attorney, right? You're sick, you can't speak for yourself, and you leave a set of instructions to somebody to take care of so that they can make the proper medical choices for you. Some people, with modern technology, you can be held in a state of suspended animation. And some people want to receive like all the living available like medical treatments to keep you alive, right? No matter how intrusive it is, they want it. But some people don't. Some people don't want to be plugged into a machine and be a vegetable. Like they'd rather just, I hate to say it and not to be harsh, but like to be unplugged, right? A situation like that happened with my own father-in-law. He was sick. He had a perforated ulcer, and they were going to do a very intrusive procedure, right? Where the percentages weren't going to be great for his recovery. And one of the siblings, my sister-in-law, who also happened to pass away at a very young age due to like lung cancer, she didn't want her father to be, she wanted her father to get every kind of treatment, right? And then, but the Advanced Healthcare Directive said no. You know, some people don't want to get like every life-saving treatment, right? The other thing that the Healthcare Directive does is you can address organ donation, and with the HIPAA waiver that will accompany it, you can designate people that you want to get your medical records, right? Because HIPAA is a very strong, the Health Information Portability Act, Information Act, or whatever it is. You might want to designate people to be able to get your medical records. The other thing that we try to help plan is, do you want to be cremated? Some people don't want to be buried. Some people want to be cremated. I just don't recommend spreading your ashes in weird places. Like there's actual societies that help you coordinate the spreading of ashes, things like that. I've had people give me long playlists that they want to play during their, viewings and stuff like that. Here you get to customize it. I think the important thing here too is they're not making a decision about how you want your body and remains to be taken care of because of some conversation you had over Thanksgiving dinner, right? Because that happens, because sometimes people just don't have a plan, and siblings may argue. They may say, well, this is what mom wanted, or this is what dad wanted, or dad told me this in the summer of 2021 that he wanted to be buried in XYZ place. Like this is your opportunity, we feel like, for a very reasonable cost to be able to address like these things so that when the time comes, and it's coming for everybody, right? That you'll be able to know and have peace of mind that your wishes will be fulfilled, right? And that what you wanted for your ceremony, for your burial, will be as you planned. So that's the critical thing with a lot of these documents. I mean, these are your wishes, right? Okay, so important people. If you got minor children, you might want to nominate a guardian. And unfortunately, the world can be full of predators. So can you imagine, like, if a minor child, is now set to inherit like a large sum of money? I hate to say it, some families, or almost every family might have a person in there that might be, just trying to take advantage of a child, because they're going to come across a large sum of resources in the event that someone has an untimely passing. So it's something to think about. The trustee, it just needs to be someone that you can trust that will distribute the assets according to your wishes when you pass away. So, for instance, hypothetical, if I pass away, then Tim is my trustee. Then Tim would look at the trust document, which will have the guardrails on it, that have the instructions in it, that will tell them what to do in the event of my passing. So that way, Tim just has to pick up this book and say, okay, this is what I need to do for this is what I need to do for that, and this is how Rich's 3 kids will get X number of assets, right? And the trustee has a legal fiduciary duty to the beneficiaries to not loot the trust. He can't self-deal, things like that. He has to he essentially works for the trustee. So whoever you pick, I suggest that you talk to them first to see if they're willing to do it, because it might not be an easy job. The other thing too is there are professional fiduciaries available that actually are trustees for a living. So if you don't have a relative that you trust or a friend that would be willing to do this, you can hire somebody to do it. Any questions? I'm going to pause there. No, everything making sense so far? Okay. Moving along here. So This is where we try to get crowd participation, but I get it if you've been working all day long and don't feel like having crowd participation, that's okay. But anybody believe that after what we talked about, that a will avoids probate? You can just type your answer in the chat if you want.
Mhm.
The answer is false. All right, move quicker here. Excuse me. You only need estate plan if you have significant assets. That's false also. And sometimes people don't believe they have significant assets. You know, oh, they just say, oh, I just have a house. But like in California, if you got a house, that's like that could be like $700,000, $800,000. Right. So don't believe that just because you think you don't have significant assets, that you don't need a plan, right? Um, you know, you might have heirlooms and things like that you want to make sure go to the proper people. We had a couple that had like a fine china thing, that set of plates and things that they brought from like Germany and all this stuff, and they wanted to make sure it went to, you know, a specific daughter because the other kids wouldn't take care of it, right? So this is also a chance for like for you that may have heirlooms or like jewelry, or you know, who's gonna get mom's wedding ring, right? Or who's gonna get dad's classic car or something like that, right? Um, Something to think about there, you know, specific gifts. Again, trying to put a plan together to avoid fights or litigation. A will protects minor children. Not exactly. Um, like you could name guardians and things like that. Uh, but your trust will allow you to like, you can specify ages for when they can, you know, be able to get proceeds out of the trust, right? You know, when I was 21 years old, I was probably a pretty irresponsible person. So maybe for my kids, if it's hereditary, I'm joking, but maybe they maybe they shouldn't inherit anything until they're like 25. And maybe if they want something before they're 25 out of my estate, assuming that I pass away before they're 25, they can only use it for education and medical expenses or tuition, education, tuition, that kind of thing. So you can put provisions around like the money that's left. The other thing you could do too is, let's say you have an adult child that lives with you, right? But they have siblings that no longer live with you. Maybe you want to protect the child who's living with you by giving them like a life estate in the house, so that the other kids can just kick him out, right? Or get their share because you want to give like, you know, equal shares of the house to all your kids. It's not uncommon, right? Having, you know, it's like that movie Failure to Launch. You might have a kid that just isn't moving out yet, or not ready to move out yet, or is living with you to take care of you because you're, you know, elderly, something like that. So those situations happen. And we're not here to tell you necessarily how you want to do, like how you want to distribute your assets. We're just here to give you advice to help you put the best plan together to try to avoid any contests. Okay, I'm going to move quicker here because we only got 15 minutes. All right, so again, wills don't avoid probate, trusts do. You can specify healthcare wishes, nominate guardians, and leave specific gifts in both documents, but trusts can help you set preferences for those assets. Cover expenses for a guardian, right? Like if you have a minor child, um, you know, they're going to have expenses, um, and things like that. You could also protect people who have disabilities, like in a trust, right? There's people with special needs that might need complex trust instruments for like Medicaid protection trust, things like that. So yeah, trusts are very flexible devices, and there's a lot of things you can do with them. And we'll go through some of the benefits here shortly. Okay. So one of them is like the step up in basis, right? Uh, let's say I bought a house in 1983 for $100,000, right? Which is my original cost basis. But then I pass away. And now the value of the home is like $900,000. And Tim, the beneficiary, sells the home for $1 million, right? So if you're following the scenario, you get the cap, the home is reevaluated at the time of my passing, right? So my tax is only going to be $20,000, right? So the difference between the $900,000 when I passed away and the $1 million in which Tim sold it leaves a gain of only 100,000. So at a 20% tax rate, it's only $20,000. So one of the questions I always get is, well, why don't I just deed the property to my kid while I'm alive, right? But if they're, excuse me, but if they're not on the original, if they weren't there when they originally purchased it, and hold on, I can clear my throat real quick. Then they're gonna inherit, or when they eventually sell the property, they're gonna get your tax basis for when you bought the property, when you add them during your lifetime. So you don't want to add them during your lifetime. You want them to inherit it via a trust, so they can get the capital gains step up in basis benefit, and then they're just taxed less. So that's pretty straightforward. Any questions? So you basically get the value of the home at the time, like if one of my kids were to, what did I use a scenario? Oh, Tim inherits my house. So yeah. So when I pass away, the value is established at the time of my passing, then Tim gets the step up in basis and the tax savings. Okay. This other one is a little more complex. And we don't have all the time to like talk through it. But let's say you have a 401k plan or some kind of other tax deferred account, right? And you can distribute that outright, right? Like if you have a retirement account, you name who gets that money. But the thing is, that person, like let's say in the case that they get $1 million, which isn't unheard of in 401ks if you've been working for like one company for 25, 30 years and you've been putting the max away. It's not uncommon to have like $1 million, especially if you work for big companies and they match you, right? You could accumulate a large sum of money. The thing is though, if you inherit it right away, for that 1 year, you're going to be pushed into a new tax bracket. So if I get the lump sum, I'm going to get the top tax bracket is $500,000, right? So the tax rate for that person is 37%. So if I inherit that $1 million, I'm going to get, not including their income. So this is just to make an easy number, easy graphic, but let's say it's $1 million, you're going to get taxed $370,000 on that $1 million. But in certain kinds of trusts that you can create, right, after you pass away, and as long as you meet certain requirements, you can extend your tax deferred account for another 10 years, right? The RMD amounts and things like that will be determined against the oldest beneficiary, right? And then what happens is like when the RMDs are taken out, they have to go straight to the beneficiary, but the money can be reinvested while it's still in your tax deferred account, right? So this is another way to have generational wealth. Is imagine if after you pass away, you can still continue your tax deferred account for another 10 years. Now this is a complicated setup. So you would have to, so even though you pay more taxes later on, assuming an 8% interest rate, 24% tax rate and a RMD of 100K, right? You can still grow that $1 million, right? So even though you get taxed a little bit more 10 years later, it can only stay in there for 10 years. But yeah, a little more complicated setup. But another instance of where a trust, so not only avoiding probate, also, having a house, be able to get the benefit of the step up in basis, but also, if you want to do something more complex, again, you have to have a trustee to manage this for 10 years, right? So not everybody wants to do that. Some people just want to have a trustee and then just give my stuff away right away, right? But I'm just saying that these sort of options are available to people that want to plan them. Okay, any questions? No? All right. So benefits real quick here. We got 7 minutes left. Asset distribution, minimizing taxes. You can name a guardian, right? Avoid probate delays. Again, like why not just have a plan so that when you pass away, your loved ones aren't scrambling to figure out what to do. That's critical. Healthcare decision-making, financial management, right? The power of attorneys that we talked about. So your estate plan is not just what happens after I pass away. It's this combination of documents that you get that will speak for you in the event that you cannot speak, right? And you can always change it also. So it's not always written in stone, but you might want to update something. Hell, you might want to disinherit your middle child. It was some days where my middle child just drives me nuts. Just kidding, love my son, but you get the idea, right? Business succession planning. You can also give to a charity. Conflict prevention. That's the critical one. You don't want your siblings fighting over mom's favorite lamp or dad's favorite cup, right? You can name those things and tell people